I am an attorney at Callaway Golf Company and a member of the board of directors for the San Diego ACC. I'm happy to see we have a couple of other board members today on this presentation who'll be listening in, including Sven Batzabka, our president, and Diana Cohen. And I also wanted to sincerely thank Procopio for being one of our most steadfast sponsors as a platinum sponsor. So our speaker today is Miku Maeda, a partner at Procopio, who will be presenting on the legal fallout from the Ukraine war and other global tensions, the latest in sanctions and export controls. In addition to being an experienced intellectual property attorney with deep expertise in various technologies, Miku is an expert in export matters, particularly parent subsidiary arrangements with a focus on Asia. We're excited to hear his insights on how the war in Ukraine has impacted sanctions and export controls. So I will hand it off to Miku to start the presentation.
Thanks, Rebecca, for a really great introduction, and thank you for allowing us to sponsor and host this event, and for letting me give some introduction to the current situation with export and China, Ukraine, and beyond. So I'm going to share my screen. Hopefully you can hear, but if you can't, then put in a chat or raise a hand. Let me first share the screen. And what I'd like to talk about today is just what's going on in the global marketplace and give you some ideas based on that. My idea for an agenda was first to give a little background on principles and practices, and then some of the common situations with entities deemed an intra-company that we see here in California quite a bit, and then go into what's going on in China and Russia. And I have a couple of recent news items. One you probably saw yesterday, the additional entities, and then the notice of final rulemaking for some additional semiconductor technologies for China, and then just a few takeaways. So as Rebecca said, if you have questions, please put them in the chat. The way that I'm sharing the screen, I might not see the chat right away because I'm sharing the presentation, but I'll toggle back and forth every now and then, and I'll address them or answer them as best I can in progress. So first, some general principles. So I think you all know this: exports is not just physical goods. It applies to when we have foreign nationals employed in the United States, when we use contract manufacturers or supply chain, value chain for overseas manufacturing and send them some technical information, as well as R&D, cross-border R&D, where we're doing the R&D here for a foreign headquartered company or vice versa. There's national security, there's some absolute liability. Some of it's mitigated potentially depending on the situation. And there's a lot of risk in terms of the penalty and loss of export privileges. You're probably familiar with the penalties, criminal and civil, under the different rules, but in case you're not, I just listed them here, and I think you'll have these materials. But there are both civil and criminal, individual and company for various situations. And then just a couple of cases of interest just that we've seen, and then I have one at the end that was more recent that I'll show towards the end on China. But one is Yantai, which is just an export of equipment worth $383,000 to Iran that was for oil fields. And then during the investigation, it was determined that the company had made false statements that by the then vice president. So for the export of 383,000, they had a much larger, probably almost 10 times larger or 9 times larger penalties that accrued to Commerce and Treasury. Access USA is another one. This was related to the undervaluing of items and violations related to export of certain controlled items. And the penalty was quite substantial, both for the individual and for the company. So you can see it going both ways, individual and company. And then a couple of more of the high-tech ones, one on China and the other on China, Ukraine, and Russia. So multi-wire, there was some camera detectors that were provided to a company on the entity list, the University of Electronic Science and Technology of China, without getting a license. And as we'll talk about later, some of these are under presumption of denial, so you probably couldn't have gotten a license if you applied. But they had a fine of 80,000 for a transaction of 177,000. And then Maxim, this is an older case, but the employee, there was an Iranian employee and a Chinese employee that were involved in R&D. And so there was unlicensed export, but to the countries as well as to the employees. So you have deemed there and you have a civil penalty. And you've probably seen the link, but I put it here anyway. And this is, the link will probably be updated as the new one comes out at some point. But this is just a BIS publication with examples of activities that we shouldn't let happen to us. And then just generally, we're going to talk about EAR. So we're talking on the left column here on your screen. That's the EAR regulations. The latest update was in 2018, the ECRA, which is a reform of the export control laws. And then you also have under state and treasury other restrictions and requirements under national security. So as you know, an export is an actual transmission or a transmission of technology that is subject to EAR outside of the US. The items that are subject to EAR, they're items that are not subject to another agency's review. Another agency might be, Department of Energy, NRC, Defense, or other agencies. Items in transit through the US, US origin items wherever they go, whether it's through export or re-export. Foreign made items that incorporate US origin content or technology. This comes up under direct product rule. And then activities of US and foreign persons. And then some areas of concern are, of course, proliferation, chem bio, and missile technologies. And then there are other orders that are issued under the EAR from time to time, and those activities would be considered to be prohibited. Some items would not be subject to EAR, excluded. Some examples would be publicly available information that is freely accessible to the interested public, libraries, released at open conferences without restriction, product of fundamental research that would ordinarily be published and broadly shared, again, without restriction. And that's important to note that there's no real proprietary component to it. If you're doing joint research with universities or other parties, it may not be subject to publicly available or fundamental research if access is some partially or completely restricted. So the point is that there are things that are not subject to EAR. Here's a few more: published patents, educational information, meeting the academic criteria. And then I mentioned this before, but just to reiterate, there are other agencies that are involved in export control. DDTC, NRC, DOE are examples. So they may have jurisdiction as opposed to the BIS. Shipping out could be physical or release of technical data, but there's also this other part deemed that is the release of source code or other technology information to a foreign national in the US. We'll get into one of our situational examples on that. And when a foreign national comes to visit, customer, executive, manager, that when they visit the facility, that's an export. It may or may not require a license, but it's important to know that's an export, even if the member of the headquarter company, if you're in a subsidiary, they come here, even if it's the same company. If they're a foreign national, that's considered to be an export. And I've just listed some of the other things that could be exports here. Keep in mind, email, internet postings, visual inspections, meetings, in-person meetings in a conference room. If you have a open office where everybody's working in the same office and can hear one another, it's possible that there could be an export of information as a part of an in-office conference. So we have to be just aware. Again, may not require a license, or you may have a license, but you need to know that some of this is considered an export. So then how do we know if something is subject to EAR, how it's controlled? There's a ECCN system where the BIS has a technology-based approach. It's categorized based on 10 different categories. They roughly go and map out into various different technologies. I've just listed them here. Commonly, we'll come across in the high-tech area the list 5, 4, 5, 6, and 7, but aerospace is 9. You'll come across these depending on what your company is doing. Just be aware of how this is set up, and then within each ECCN or each number of the ECCN, there are 5 different categories related to basically different pathways for export and interaction: product, material, software, technology, testing, and then different ones may have different levels of restriction. If we're talking about technology, that may be how the technology is made or innovated and have more information that should be restricted as opposed to the product, especially if it's difficult or impossible to do a teardown on the product. So an ECCN for 992A or 992E may have a different different level of restriction. How do we determine what the level of restriction is? When we go to an ECCN, we'll see some exceptions and exclusions and exemptions. And if we don't fall into one of those, as we go through, we need to look on the Commerce Country Chart because there's a code for the ECCNs. You can see the different codes, CB1, CB2, et cetera, going all the way over to AT1 and AT2. And they map out, and there's a grid. So you have to look at your country of interest. First, you check your technology of interest, then you check your country of interest. And X means it's controlled and you may need a license. So, and there are a lot of reasons why you may or may not need a license. But this is just a very high level explanation of how to figure out if something is subject to EAR, what is the ECCN, and for my country of concern, what might I need a license for? If something's not on the list, but it's subject to the EAR, it goes into EAR 99. And typically no license would be required, although there are certain exceptions under certain special special rules and things like that. So some situational type activities. One would be the entity list. The entity list, and there's a website that has all of the lists. It's called the Consolidated Screening List from all the different agencies that you can search on. It has a literal search, a fuzzy search. It's pretty good. It's pretty useful. I'd avoid downloading lists because these things change very frequently. I'd go to the website to look them up. But the BIS does keep this list, and it specifies the licensing requirements. It's more of a chart that it imposes on each listed person, and those entity requirements are both independent of and in addition to the standard license requirements that would be imposed. So if you have a Russian national or Chinese national that has been added to the entity list, those are independent of and in addition to the license requirements imposed elsewhere in the EAR for deemed export to that country if the national is in the United States, or to that country if the national is outside the US. Now, there are exceptions we'll talk about with Russia that deemed is not covered under some of the Russia rules. So we have to go into the details to sometimes figure out if it applies. Another situation is subsidiaries and parents and sibling companies. So when you have an entity, the restriction is for the listed entity per se, and usually what they will do is they will list out all the subsidiaries and related companies that should be on the list. I think the Huawei list started out in the 30 or 40 and grew to 70 and maybe over 100 by some point. So you have to be careful. You have to be careful about a couple of things. Sometimes a company that is not on the list may be acting as an agent or a front to facilitate transactions. You just have to use your best judgment and diligence for that. The other thing to keep in mind is that if a company is one of the entities but is not on a list, but many of the other entities on the list, you just have to be aware that there's a possibility that that entity could be on the list in the future, and you may want to have a risk management plan, kind of a emergency escape if you have a contract manufacturer and several other entities that were contract manufacturers are on the list. What happens if this one also goes on the list at some point? You want to be careful about those kinds of things and just have a contingency plan. So the list is the kind of first situational area, and a lot of what's going on with China and Russia relates to the entity list. Another area is deemed, and we talked a little bit about this already, but the deemed export is a release of technology to a foreign person in the U.S., where the transfer actually occurs within the U.S. The deemed country is deemed to be the most recent citizenship of the foreign national, and sometimes a government license or other approval, a deemed license, may be required. So, I've listed some ways. I think if you have interactions like joint research agreements, it comes up in diligence for example, for M&A. If you're acquiring a company and there are foreign nationals in that company, what information are you disclosing to them? Or if you have foreign nationals in your company, what information are you receiving from them that may not be controlled or may not be controlled? Ask about when you're interacting with organizations in the U.S., ask and confirm their export policy and who's responsible for telling whom about the ECCNs. Be sure to disclose if you have ECCNs and you're working on a joint research agreement and you don't know, or that there may be foreign national researchers on their side. It should just be addressed, I think, at the early side. But these are just examples of how deemed exports can occur. And then the status of foreign person, if you're a US citizen or a green card holder, or you were granted asylum, refugee, or amnesty, you are a US person, not a foreign person. It's important to keep in mind that other visa statuses still are foreign person, including H-1B, H-3, etc. So that's even the training ones, you have to be very careful about these points. So what are some things to be careful about? You want to, at least at the start, identify, well, what technologies will the employees be interacting with? What are the countries of concern? And then if there are risks, you have to determine your internal physical and electronic access control. What projects will they be working on? What product lines and services will they be working on? And I would say that at the earliest point possible, because there's, it's a 1 to 2 month process typically to get the deemed license through SNAPR, sometimes longer depending on the situation. You should apply for the deemed license as soon as you know you're going to need it, and consider the possible projects that they could be involved in at the earliest stage. So some special issues. So what if you apply for a license and you get approval? Keep in mind that those licenses are personal to the company, person, and technology that's listed. If you have a new hire, even if they did have a deemed license from their prior company for a similar technology, because you're confirming the physical and electronic security information, you still need to apply for a new deemed license, even if they're coming from another company. If they move to a different control technology area, or if you're anticipating that, you'll want to apply for a new license. Keep in mind also that there are some guidances from DOJ and others on what you should and shouldn't and can and can't do in the recruitment process, as far as asking about nationalities and things like that. Last one, keep in mind, I mentioned this before, customers, suppliers, any part of your value chain could be an export if they come to your facility and you share information. So that doesn't mean they can't come, and it doesn't mean you can't share information. You just have to be careful about what you're sharing. You may need to screen, or you may need to do a quick compliance check to make sure that there's no license required. And then intra-company, just quickly go into this one, and then we'll move to more of the country basis. Transfers within a company are exports if they are across borders. Access to information is an export. So here's some examples. Cross-border research teams sending status reports or invention disclosure information cross-border, and product specification, design detail, manufacturing specs, from design to manufacture. That's also export. Even if it's within the same company, unless you have some kind of validated end user agreement with the BIS, it's usually considered to be an export, just the same as if it was a different company. So some ideas, then make sure you have a good internal policy for classifying the ECCNs for the technologies. Determine whether there's an exception that may apply, and document the exception. Some of those things change over time. License, do the diligence, have a process for doing the diligence as early as possible, and apply as soon as possible if you think a license is going to be needed. Provide export control training just to understand and explain situations, and then have an export team or a chain of command for handling export questions. So now we're going to move on to first to China and then Russia related export controls. So here's a chart. There's a lot that's been going on with China over the last 10 or so years, maybe almost 15 years. Under President Obama in 2009, they first started to study the system and make some proposed revisions and revamping to certain parts of the commerce control list. And then in 2013, there was an executive order to simplify and streamline. If you remember, in 2014 to 15, the ECCNs were changed dramatically, and we would get the new updated ECCN list. Some were a lot shorter, some were a lot longer, and this was a big overhaul after a long time of the ECCNs. And then there was the ZTE enforcement action based on an Iran violation in March 2016. This trend continued under President Trump. We had the follow through on the ZTE enforcement action. ECRA was passed into law in 2018. We had the Huawei sanctions and bans and TGL. We had restrictions on AI-related Chinese companies that were put on the entity list, neural net regulations, and other expansions that go on today. We just had, I mentioned, 7 more entities. We've under President Biden, I think we've had over 100 new entities added to the entity list, and another technology notice of final rulemaking was issued a couple of weeks ago in the semiconductor, and we'll talk a little bit more on that later. So we have, just to go through this, we'll just summarize. And about 3 years ago, the BIS added 60 plus entities on a Friday to the entity list, and indicated that that technology could not be exported to any of these entities without a license, and to suspend business. The following Monday, a TGL was issued that gave some carve-outs for certain areas: equipment maintenance, 5G development, and cybersecurity. And then they added a clarification on use of standards if it's EAR 99 technology. Quick note on direct product rule, because that's going to come up here as we discuss further. For goods that are a direct product produced by the use of technology or software of certain U.S. technologies, if the U.S. technology is restricted for national security reasons, then when the direct product rule is applied, the restrictions also apply to the export of the technology for the development in a third-party country, even if the product isn't made in the United States. And this rule is for restriction of transactions on foreign manufactured products based on restricted technologies. And in the past, it hadn't really been applied as much to telecom, semiconductor, and computer hardware. So what they did for the Huawei rule is they applied the DPR to certain ECCNs for the prohibited Huawei entities. So the DPR was limited to the Huawei entities for these ECCNs, and that's how it was applied. It was about a year after the original rule, and then so that's a very rough background on the Huawei restrictions. So now going to other restrictions, the last in October of 2019, and then about a year later, the BIS added entities focused on AI, surveillance, drone, human recognition technology. And that list has been expanded to several hundred. And now thereafter, there was another expansion to include semiconductor and other areas. So you'll want to, the BIS has a auto email that goes out every time there's an announcement. You'll want to get on that listserv and make sure you're receiving the list of entities so that you can know, particularly if it's in the area of your supply chain, value chain, etc. In January 2020, there was a temporary rule issued on certain types of neural training software. The rule is very broadly worded that for the four technology restrictions noted below, UI with pixel variation using deep CNN for geospatial imagery. There's a little more to it than that. We don't have time to get into all of the technology details, but keep in mind from time to time the BIS puts out these restrictions, and given the amount of innovation and development of UAVs in the last few years, and drones and things like that, and even automotive that would use these technologies, we had to carefully parse this rule. And because a lot of that technology transfers with China, we have to also very carefully look at the entity list when we're working in these technology areas. Certain license exceptions were eliminated as well for civil end users. I mentioned that there are license exceptions to certain ECCN requirements. And so the effective June 29th, that license exception was eliminated. This was due to the US government's determination that there is an increased integration of civilian and military technology development in China, and requirement to pre-approve these transactions by license. MEU, there was an expansion of military end-use restrictions, and the focus would be, for these, was China, Russia, and Venezuela. One important thing is to determine whether you're dealing with entities having an association, and it's not so easy, with the militaries in China, Russia, Venezuela. Check the entity list, but also do your diligence. And keep in mind that as you see these announcements come out, it looks like the US government is broadly construing associations between companies and militaries for the purpose of these regulations. So let's move over to Russia and talk a little bit about the categories of sanctions that are going on there under EAR. There was a rule effective immediately February 24th that implemented these EAR measures. It was expanded to Belarus. And there are 7 main parts to the rule, which we'll go through just kind of to quickly summarize them. They're all somewhat different from one another. But one thing to keep in mind is that the rule does not currently apply to deemed exports. The licensing obligations on the release of the code and technology apply if the nationals of Russia and Belarus are not in Russia or Belarus. So if they're located outside of Russia or Belarus, then the deemed controls do not apply. So if you've hired Russian national or Belarus national, for the most part, we don't have application of these rules. Of course, you should have caution on related transactions and things like that. Here's just an initial list. This list keeps growing, but the BIS has been very timely to issue or quick to issue these additions. Most of them are additions to the entity list and clarifications on the technologies involved. So Let's go through and look at the different parts of the rule. So the technology coverage, it's a CCL-based license requirement for Russia, including new license requirements for ECCNs 3 through 9. And there's some areas that were previously not controlled for Russia, and I've listed some of them here: navigation, avionics, aircraft, all of these areas. So the first point is that the CCL applies for all ECCNs categories 3 through 9. Then there are two different direct product rules. There's one for Russia generally that controls foreign produced items. So you can't if something is a direct product of certain U.S. origin software technology, or it's produced by certain makers or component makers, which are the direct product of those technologies, then the direct product rule applies. They've made certain exceptions for EAR 99 and consumer items that may be used by the Russian people, and they've started this concept of partner countries. There's a large list of partner countries, and there's an exception for partner countries that is based on those countries having kind of an equivalent regime. Then there is a different FDP for military end users. That's for any technology subject to EAR under DPR, including EAR 99 for Russian military end users, and that's a very broad military end users, direct or indirect. Parts 3 and 4 I've just put here as limits on relief. There's a presumption of denial as a matter of policy review for all of these requirements. And there are limits on the normal ECCN type exceptions you would have. There's a restriction on the use of EAR license exceptions. Only certain sections are available in very specific and limited situations. It's important to read through and understand what those could be. But there are significant limits on relief. It's very different from going through the ECCN, determining that there is some kind of an exception and no license is required. You'll actually have to look through the reg. Entities and end uses. That's parts 5 and 6. MEU, again, expansion of the existing military end use and MEU control scope. This includes all items subject to EAR except like food and medicine and certain 5992 items, so long as they're not for government end users and Russian SOEs. But you have to be careful because there's some diligence that you would want to do to make sure that it's not the end user is not Russian government end user or Russian SOE. And then the entity list, the Russian entities were transferred from the MEU list to the entity list, and some expanded license requirements were imposed, and additional entities continue to be added, and this continues to be expanded. So that's the kind of parts 5 and 6 of the Russia rules. And then there's conformance for they call DNR, LNR, and Crimea that are conforming to the Russia-related sanctions for Russia and Belarus. So this is just an overview of the structure of these sanctions. The BIS has started to issue the release of the orders as the enforcement actions happen, so they can explain, and so the public can understand the types of situations the BIS is interpreting to be export violations. It's very helpful to have access to these and read these reports from time to time as they come out. So that's that one. I think if we have time, we can come back to supply chain, but I'd like to talk a little bit on the recent BIS updates, because we're already at 12:50. This is just the updates in the last couple of months. One, I think, is cautionary. We have to pay attention. And this is the caution is more of have a policy, have in-house training, and have good oversight. So what happened is in the three companies that collectively use the same rental mailbox received these drawings from their domestic US customers for 3D print requests. And without letting the customers know, they sent those drawings to China to have them 3D printed without getting a license and have them imported back into the US to the ordering customers. And then according to BIS, the information that was sent contained sensitive prototype space and defense technologies. So the BIS issued a temporary denial order for the companies for 180 days, where they can't export anything subject to the EAR, and they can't receive or participate in exports or re-exports. And then their customers are prohibited from taking any action that would facilitate these companies taking possession of such information intended for export. And then you can just get a flavor of the BIS notes on this. So we need to be careful. And this is at the level at which the export occurred, is that it was individual drawings that were sent, individual information, and there was a shared rental mailbox. There's a lot of things here to be careful about, but the important thing is to understand in the process of export and make sure all members in the process of export have training and understand policy and when not to export. And more importantly, when they don't know, they know that they should ask. Next one is, this came out about week and a half ago, maybe a little over a week, almost 2 weeks ago. New multilateral rules in interim rulemaking. You can see the FR there with the request for comments. The comments that they request are more clarification on examples of products and other technologies that would go here. But this is under ECRA, the 2018 law. And basically for 3D006, ECCN, there is an NS2 and AT1. You can see the country chart, but it's, NS2 will be fairly restrictive. And it's for 3 different areas in the fabrication or semiconductor area. One is for gallium oxide and diamond, to restrict them under the ECCNs under the 3C001 to 5 and 6. And they've added some new paragraphs and restrictions on those substrates, on the export of those substrates or certain technologies associated with those substrates. The second area is ECAD for GAA FET. That's his design tools for development of 3 nanometer and below. And so the ECAD software will apply when it is specially designed for, whether it is exported with or without the developer kit. And the BIS is asking what features are suited particularly to these circuits, and they may add certain guidance on this. And the last one is for gas turbine components for aerospace and hypersonic systems. There's a new ECCN information under 9003 to control development and production technology for this area based on aerospace, rockets and hypersonic. This has been added. And then a last one, this is from today, actually would be yesterday. Some more entities, and this is related to aerospace mainly. I think seven more entities. I have one of my bullets off on the right there, sorry. But so now we have 100, as I mentioned, 110 entities added in the last couple of years. So maybe last year and a half. So the trend continues. Please be careful with the entity list. We can go back. I can just mention the supply chain because we have it here, but you have this in your materials. But just keep in mind that if you have contract manufacturers, you want to, you have direct entity list issues, possible direct product rule issues, various different types of export issues may occur in supply chain. And so it's important, I think, to be aware. How do you handle these things? What should you be prepared for? You should have in your contracts some contingency for how to handle this situation. What contractual obligations would survive a designation of an entity on the entity list, if any, rather than having it silent. Obtain a letter of assurance if you're not certain if a contract manufacturer then uses subcontractors or sources or sends information to restricted companies. Get a letter of assurance if you need it. And you may need to have internal procedure for how you request a suspension of export, how you deal with suspension or termination under contract, and how you deal with any notice provisions, as well as any local law regulations if it's in a third party country where the manufacturing is happening. So internal training is important. Having a plan is important. Knowing how to handle more granular things like de minimis and calculation of fair market value. Those are all things that can come up in supply chain. So the main thing is knowing the exports, knowing your value chain, knowing all end users and uses as the best you can. And then the emergency plan. This is an area like if you have to shut things down pretty quickly in a supply chain, it's it's very hard to suddenly say, even within a few weeks, where we need to switch sources. But you have to have some kind of plan for how to deal with this. Maybe it's diversification, maybe it's a emergency plan, break glass, whatever you want to call it. But you should have a plan to think about how you would handle these situations, because there's a lot of entities that are listed, and you can see that the regs are growing quite a bit. It's the same takeaways that you would have and know from the rest of the discussion, which is know the risk, identify the risks, whether they're deemed, whether they're related to specific countries, whether you're going into a market where some of these entities are either in the customer chain or the supply chain, identifying potential risks of collaboration, training your teams, whether they're sales and marketing, R&D, onboarding, legal, on these risks, having a plan for if you are audited or if you are approached, how should your team members address the risk to reduce the risk, to de-risk or down risk, and then having a self-audit process where you regularly check your plan, make sure it's up to date on the regulations, and making sure that your members, when needed, are able to execute on the contingency parts of the plan. I think those are the main things. So that's what I had, and I see that, see, I'm not looking for in the chat. I didn't see any questions. I don't know if there are, if Rebecca or Audrey or anybody saw any or had any, but this is the information. This is the information that I wanted to share with you about what's going on. Just keep your eyes on the BIS announcements. If you're responsible for mill and OFAC and other areas, keep your eyes on that. But this is a growing area of regulation and activity. So I'm really grateful to be able to share this information, and thank you for your time. And unless there's further questions, I would turn it back to Rebecca.
Thank you so much. That was a very informative conversation. We do have a couple minutes left before they hit the end of the hour. So if anyone has questions, please do send them in the chat or shoot them to us on email, and we'll make sure that Miko gets them. The slides should be available on the website, the ACC website, shortly, or you can reach out to Audrey at ACC SD to get a copy. So with that, I think we can close it up for the day.